My name is John Cherry, and this is my presentation on collective bargaining and the basics of contract negotiation. We're going to start by looking at some terms that you need to know that I'll be referencing later in the presentation. First is collective bargaining agreement. This, simply put, is the contract that will be worked out between the two sides as they engage in collective bargaining. Next is the idea of exclusive representative. This is particularly for the workers, this is who is going to bargain on their behalf, what organization. In this case, usually it's going to be the local union, right? And it could be for the teachers, it could be for the support staff. That's really going to be determined by the next term, which is the bargaining unit. That is really a term that just means who's bargaining, what group of employees. It could be teachers, it could be support staff, it could be both, and which is a term often they'll usually call wall-to-wall. Next term is called good faith bargaining. This is, simply put, you're engaging in this process of collective bargaining with the intent of reaching an agreement. You are trying to actually come to a deal at the end. Sometimes, you'll hear one side in a really contentious negotiation charge the other side is not bargaining in good faith. There's a legal definition of that is often not the case. But rarely is actually invoked, but it's often used in public relations to say it's not our fault, it's the other side's fault if there's a problem in the bargaining. Next is the term impasse. Impasse is when one side feels that we're not going to reach an agreement. We've come to a point where we are at a stalemate, we've hit a wall, and it does not have to be both sides agree to an impasse. Impasse just means one side is like, we can't go any further. We've reached a point where we cannot continue to go on. And so that's the first step of many towards getting to a point where once, the workers may choose to go on strike is to declare an impasse. Next is mediation. Often when there's been an impasse declared by one side, they will request a mediator. This is usually a federal service. Federal mediation service will come in. This will be a neutral person. One person will come in and serve as kind of the go-between between the two sides if they are at a point where they feel like they cannot progress any further. That mediator is just going to go back and forth between the two, talk to them, try to get them talking again. This is often at a point where if sides have been negotiating for a long time, months, sometimes over a year, they get tired of talking to one another. It's nice to have somebody else sitting in between them that's got fresh face, fresh ideas that can help move the process along. Mediators also have the ability to do what they call a supposition, right? So in bargaining, there are proposals. Each side presents, their proposal. We propose this. This is what we want, right? Either what we want to gain or what we want you to give up. The mediator can do a supposal. So when you present a proposal in bargaining, you are bound to that. Once you've proposed something, you cannot go back and get worse than that proposal. If the board proposes that they're going to give a 2% raise to the staff, they can't come back in their next proposal and say, well, now we changed our mind, we're only going to do a 1% raise. It's called retrograde bargaining. It is illegal. But a mediator isn't tied to those rules. So a mediator can come in and say, well, suppose they gave you 2%, but also gave you this on insurance. It's not an official proposal. It's just an idea. It's a way to talk back and forth. What do you think about that? What if they said that? But no one's hands are legally tied. So that can often move the process along. And then the final term that's on here is the Illinois Labor Relations Board, the ILRB. This is the organization in Illinois that oversees public sector bargaining. So that is government unions, people who work for a government body, whether it is a school, a police force, a fire department, a municipality, the state of Illinois, whatever. They oversee the bargaining of all those different organizations that bargain with government agencies. So what is collective bargaining? The Oxford Dictionary defines it as the negotiation of wages and other conditions of employment by an organized body of employees. Fancy definition to basically say it's when a group of employees gets together to go in and talk about their terms of employment, what are their working conditions going to be. And so that's going to encompass a lot of things. We're going to talk about what can be talked about on the next slide. But in an educational setting, this is really going to be the Board of Education and the employees, whichever group of employees it is. The board is the negotiating body for the district. Now, it all depends on what district you are in for how the board handles that. I have been in negotiations where 1 or 2 board members showed up. I've been in negotiations where 4 board members showed up, and they had to, every time they bargained, they had to declare it a special board meeting and then go to executive session. I have been in bargaining where no board member showed up. There was one group that I consulted with a few years back that it was the superintendent, the HR director. They had 8 buildings in this elementary district. All 8 principals had to be there the entire time, and the curriculum director. And so they had 10 people there. None of them were board members because the board in that district basically said, we pay you people to do that job, handle it. So as an administrator, you could end up sitting in on a negotiation. It really just depends on the district that you work in. But it really ultimately is going to be the responsibility of the board will vote to approve the contract. So ultimately, it's either the board or their representatives, and then it's the local association, the local union, that will be bargaining on behalf of the workers. In Illinois, that's either going to be a local that's part of IEA, the Illinois Education Association, or IFT, the Illinois Federation of Teachers. Those are really the 2 main organizations in the state of Illinois. The closer you get to Chicago, the more IFT, especially in the city of Chicago. The CPS is an IFT union. The further out you get away into the rural areas, the more it is IEA. That's not 100% true, but that kind of is the rule of thumb of the way that it works. And so those unions are the exclusive representative. That's the only people that the board can bargain with. Okay, they must go through the union to bargain those contracts. That is the law in the state of Illinois. Really what that means is, as an individual member, if you have somebody working in a district who's not a union member who says, I don't like this contract, I'm going to go to the board, I'm going to bargain my own contract, they can't do it. The employee can't do it. The board's not allowed to do it. They must bargain through the bargaining unit and through that exclusive representative. And so, the hands are tied when it comes to anybody who's in those types of jobs. Now, for admin, that's different because they're not part of those bargaining units. They can then go and bargain their own individual contracts. So districts and unions enter into this in order to eventually form a contract. And when forming a contract, there are things that they have to talk about, the 2 sides. There are things they can talk about, and there are things that they are not allowed to talk about. The first area that the 2 sides have to talk about are called mandatory subjects of bargaining. These are things that have to be discussed. They have to be talked about by law. This is stuff like compensation. So wages, salary, extracurricular stipends for coaching and sponsorships and being the band director or whatever else, right? Insurance. I actually had a superintendent in a negotiation that I was the lead negotiator in tell us he was not going to discuss insurance with us. And we told him, you have to discuss it with us. It's part of our compensation. It is a mandatory subject of bargaining. He said, no, we pay for the insurance, so we'll decide what happens with the insurance. And we're like, no, you can't do that. And then he talked to his lawyer, and his lawyer told him he was wrong, and then he had to talk to us. So even superintendents and people like that don't always know the rules around this. Stuff like overtime pay, especially for your hourly employees. Do they get overtime pay after they've worked, if they work over an 8-hour day? Or do they get overtime pay if they work more than a 40-hour week? Depends on the contract. And stuff like other stipends, other hourly compensation, summer school or tutoring or detention supervision or things like that are all going to be in your contract, right? That's all part of the compensation part of it. Next is stuff like working conditions, so like hours. What time do employees have to be at work? What time can they leave? How many days a year do they have to work? Are there required meetings that they have to attend? That's all going to be in that collective bargaining agreement. How many meetings can you make them attend? Going to be in the collective bargaining agreement. That's something that has to be talked about because it's direct working conditions of the employees. And then other terms and conditions will also have to be talked about. So class size, are you going to have language about class size in that contract? And then what's that going to say? Our teachers, is there going to be a hard cap where they can't go over a certain amount? Is it going to be that if they go over a certain amount, maybe it's not hard cap, but the teacher will get money for supplies or various things? They're going to talk about what happens when we need to add or eliminate positions, right? If the district says, hey, enrollment's growing, we need to add an English and a math teacher, okay? where are we at in those at? Is it, is it a unit district and they're going in at the high school because that's where the enrollment's up? Is it junior high because that group's coming through? That's stuff that has to be talked about, has to be in the contract. The evaluation procedure has to be in the contract, has to be talked about. This is how many evaluations. Is there a time limit between evaluations? That sort of a thing. So the process of evaluation has to be talked about. RIF language. So RIF is reduction in force. What if a district has to make cuts? They don't have enough money. A lot of districts are currently, their ESSER funds are running out and they're having to maybe eliminate positions. What's the process for that? How do we determine if all the spots are filled? How do we determine, who's going to be without a job? Is it going to be based on their evaluation? Is it going to be based on their seniority? Is it some combination of both? That's going to be in that collective bargaining agreement. That has to be talked about. Transfer language has to be talked about, as well as grievance procedures. So grievance is simply if an employee feels like someone in the district has not followed the contract, what is the process for complaining and filing a formal complaint about that? Then there's permissive subjects of bargaining. So this is stuff they can talk about. They don't have to. If one side says, "Oh, we don't talk about that," they're not going to talk about it. This would be like contract ground rules. Stuff like, how many days a week will we meet? How long will we meet? If we go to caucus and we leave the room and we want to go talk amongst ourselves, are we going to do that for 30 minutes and check in? Are we going to do it for 60? That kind of a thing. I've never seen a group not talk about ground rules. But if you are ever involved in negotiation and they don't even want to discuss ground rules, it's going to be ugly. So just know that ahead of time. Evaluation criteria can be talked about, doesn't have to be. This is what's the evaluation tool that we're actually going to use when we do the evaluation. Not the process, not how many times, not that kind of a thing, but what's the actual document we're using to evaluate the teacher. Does not have to be talked about, but can be. And then also scheduling changes. That's something that the employees can have input, but the district does not have to allow them to have input. And then prohibited subjects of bargaining are things that cannot be talked about. So hiring procedure, teacher dismissal procedures. If a district issues a notice to remedy, so a notice to remedy is district has observed some behavior, some professional practice, something that they feel is not good enough or is not correct, they're going to issue a notice to remedy. This is basically just a document that says fix it. It might outline a procedure or a process to fix it. It might not, but it's usually a last step before you go to terminating someone. Is here, we're going to give you a chance to fix this that's wrong. Maybe your grades are not up to date, and therefore you need to have your grades up to date every Friday, and the admin will be checking for 3 straight weeks to see that you have updated your grade book every Friday. That kind of a thing. And then anything that would be illegal to put in the contract, anything that would violate law, obviously you cannot talk about. So importance for admin. This is obviously a program to train administrators, and so I want to focus on what is this going to look like for admin, and especially in your day-to-day job. As somebody who's been in an admin chair for a year, definitely realize how much you have to reference the contract on a day-to-day basis. So things like work hours for your employees. What time do they have to be there? We had some employees that had some issues showing up on time. I actually had to, early in the year, had to discipline an employee for being late to work repetitively. That was not fun. That was not something that I wanted to start the year with, but it had to be dealt with. And so I had to consult the contract and, okay, these are your work hours. This is the process, that sort of a thing. And that goes to one that's down towards the end, employee discipline, which I'll talk about more in a minute as well. How many days off is the employee allowed to take? How many personal days? How many sick days? How many bereavement days? That sort of thing. And what's the process for that? In our district, if you're going to use a personal day, you have to give 5 days notice. And we can cap how many people are allowed to use a personal day per building. So, there's a process there that's in that. And if a person doesn't follow the process correctly, you may have to say no, because look, I can't find a sub. I'm sorry, you didn't give us enough notice. They may be mad at you, but the contract says this is what you had to do and you didn't do it. How many meetings are allowed after school? Our contract stipulates 2 meetings a month after school, cannot be more than 45 minutes. So, and not every contract has that. I just know that's in ours. And so you may have a limit on number of meetings or duration of meetings, and some teachers are very picky about that. If it says a 45-minute meeting, our workday ends at 3:15, we get to 4 o'clock, teachers will get up and walk out because that's it, meeting's over. Is that the professional thing to do? No, but the contract says the meeting's over. Procedures for transfers. What if you get somebody that wants to voluntarily transfer? They decide, hey, I'm a third grade teacher, first grade position came open, I've always wanted to teach first grade, I'd like to transfer. What's the process for that? As a principal, you're going to have to know that to make sure you follow all the proper steps. Requirements for teaching load and prep time. See this a little more in high school, where sometimes, I've seen a contract that limited English teachers to only 2 preps. They could only teach 2 different subjects, and that was it. Because high school English, a lot of grading, a lot of essays, things like that. So you have to know that when you're making schedules. Class size requirements, is it a hard cap? That, look, if we go over 25, I have to put that kid in another room, I have to hire another teacher. Like, what does it say? Or is it I just have to give them money for supplies because now they've got these new kids coming in and they need, things for them for their room? Have to know what the contract says. Like I said, evaluation procedure. How many times do I have to evaluate? Is there a certain amount of time that has to be in between evaluations? I can't do it, one day and then turn around and do it again the next day, right? Do I have to give them 10 days in between evaluations? What does the contract say? Complaint process. What if you get a parent complaint? How do you handle that? Okay, how do you deal with that? Is there a process that needs to be followed to notify the employee of a complaint? Does it have to be a signed complaint? Can you act upon an anonymous complaint? There's a lot of complaint language that's going to be in contracts. Reduction in force. Again, this district needs to eliminate staff because maybe of cost cuts. Everybody did a really good job. I'd like to have you all back, but our enrollment went down and I don't need a 4th, 3rd grade teacher right now. We only need 3 because there's only 66 kids in that class. Whatever. How do I determine who I'm getting rid of? Contract's going to tell you often. It might be evaluation, might be seniority, might be a combination of both, but you're going to need to consult the contract on that. Definitely for employee discipline. Every contract's going to have language about employee discipline. Often it's going to spell out the process for employee discipline, and many contracts have what they call progressive discipline. So there's going to be language in there that, a first minor offense is a verbal warning, and then if they do it again, or another offense is a written warning, and then there's a suspension, and then termination, and so on, and maybe it calls for a notice to remedy in there, which generally is not disciplinary, but it can be part of discipline. So you need to know what your contract says. And then you need to be following that process correctly, because if you don't follow the process correctly and trying to discipline an employee, they're gonna then file a grievance. They're going to go through the grievance procedure, right? And they're going to say you didn't follow the contract correctly. And maybe the discipline has to be thrown out, has to be taken off their record because you didn't do it correctly. And so the contract's also going to spell out what is the process and the procedure for that grievance. Pay attention to your grievance language, because there's often timelines in grievance language that are going to tell you must respond within this many days. If you do not respond, it means you are allowing the grievance to stand. It means that you've passed it on to the next person, whatever. Okay. But pay attention to that, especially timelines that are in grievance language. And finally, some questions to consider after talking about collective bargaining and contracts. As a building admin, how can a collective bargaining agreement impact your decision making, specifically in areas such as resource allocation, teacher staffing, things like that, and curriculum and instruction? How is your collective bargaining agreement going to impact decisions you make in those areas? And then in light of the fact that we have a teacher shortage, how is that collective bargaining agreement going to influence your ability as an administrator to recruit and retain high quality teaching staff? Is your collective bargaining really good? Collective bargaining agreement really good that you're going to be able to bring people in? Is it not very good and you're going to have to work really hard to overcome that in order to get staff and keep staff? That's definitely something you're going to have to look at as an admin. So thank you for listening and have a great day.